to people in Jersey City, a little bit about myself. I'm a partner with the law firm Ford Marrin. We're based in New York. My practice is in New York and New Jersey. I live in New Jersey, actually, lived in Jersey City for a few years, and that's how I know Amy. My practice involves mostly litigation, but in connection with that, it also involves preventing disputes or solving disputes for individuals, businesses, artists, entrepreneurs before it gets to the litigation stage. So that's what I want to talk about tonight. First, how do you protect yourself from litigation or from getting into a dispute with other people when you're providing services for others, for businesses, for individuals, etc. And the primary way of doing so is drafting clear agreements and contracts which set forth parties' rights and responsibilities under the agreement. Now, the second half of my talk, I'll focus on what happens when things go south. What do you do when there's a dispute? What do you do if you get a dispute with a gallery you're working with or someone who you provided art services for, etc. And there's certain ways you can go about trying to resolve disputes before you sink a whole lot of resources into fighting with others. Now, I'm going to first start, as I said, with everyone knows the basic building block or foundation for doing work with others is through a contract. And primarily the best way, this sounds basic, but the best way to first draft a contract is to make sure it's written, right? You don't want to get into a he said, she said argument. It's very difficult to go before a judge or go before a court, even a small claims court with a claim saying, well, they told me X and I did Y, and now they owe me $10,000, and the other person saying, well, I never said that. So it just becomes a mess. It's not the way to go about things. I think if you think about a contract at its most basic level, it's like you want to write down in a clear manner using active language what services you're going to provide and what the payment terms are going to be from those services. That's where I would start. Okay, we can get to some other stuff that fills in behind that, but defining what you're going to do, and in some cases excluding what you're not going to do, is very important. And that's much easier said than done, because I see this across many industries. Many people will write a confusing contract about what they were going to do. The other side thought they were going to do something else. Now there's a dispute, and what do you do? And I was just on my way here in this afternoon, I was trying to come up with an example. I know we have a lot of artists in the room, and I'm sure you guys all do different things and have different ways of going about things. But the one sort of like easy hypothetical I thought of was like, what if we're here in Journal Square? We have on my way here, I saw these nice apartment buildings going up, etc. What if you're a visual artist or creative, and one of these developers that puts up one of these fancy buildings says, I want you to come up with a really creative decoration for the holidays in our lobby. I'm going to pay you $50,000. I want you to run with it and make it a real work of art for our tenants during the holidays. And I thought, well, what does that mean exactly? I mean, someone could take that as, well, are you going to do the design? Are you going to do the setup? Are you going to buy all the materials? Who's going to take it down? Who's going to set it up? My hypothetical, I was thinking of, someone who, as an artist, if you're in the artist's shoes, wanting to come up with a design, but you got to make that clear in the contract, because they might expect you're going to do it all, and it's going to be head to toe finished. And you might submit a plan or a schematic to have it built, but that might not be what they expect. So in terms of, in that type of situation, you want to make sure you specify exactly what you're going to do. And in that type of situation, I would spell out also, my services do not include the following things, and make that clear, because sometimes when you talk about what you're going to do, it just seems like you're going to do this broad, open thing. And you know, in a lot of industries, you know, if you go like, it comes to mind, like in the construction industry, builders and subcontractors are always very clear about this is included and this is not included, because a lot of times when you get into it, it's very fuzzy. Like, where does this particular task fall? Or, you know, maybe it's a contract for a certain number of hours. I'll do one design, but if you don't like it, I have to redo it. I want to charge more for that. So I think the most critical key provision for artists and creatives is really setting out at the get-go what you're being hired to do and what you're being hired not to do. And you know, I know that's a basic thing, but I think if you really keep that in your mind, reviewing an agreement or trying to come up with things, it will be helpful. And then the second, probably more important, is, you know, the payment. Obviously, you're going to put in this is for X amount of dollars, payable whenever. I mean, everyone's seen those provisions, but that should be tied in to the services. Another problem which I commonly come across is, you know, who are the actual parties to this contract, right? Because it's a lot of times you'll have people that have you know, LLCs or other entities, and you know, could just be a personal entity, might have no money, might not really be a business, it might just be a holding company. So if you're executing an agreement with a sort of a LLC that you don't really know what it is, and it comes time for them to pay you, and they say, sorry, I don't have any money, it really causes a headache down the road, even if you were to go to court and get a judgment, because sometimes it turns out that they're right, that entity doesn't have any money. Then you actually have to go after the individual, and that becomes another headache and requires more resources, etc. So in that type of situation, you either want to know who the entity is, what their business is, do they have, if the other side will tell you if they have money. If not, you might want a personal guarantee from someone, or have an individual execute the contract so you know there's something behind it. And another key provision sort of in this context for artists, and I know Alex is going to get a lot into this, but you know, dealing with the ownership of the work. You know, once it's done, who owns the rights to it, whose intellectual property is it, etc. Now, and this next topic, frequently you'll see in contracts, instead of you know, requiring that if there's any event of dispute, you know, the parties are just going to litigate, you can frequently include dispute resolution provisions, and even alternate dispute resolution provisions. Now, this can get somewhat complicated, but you know, you could provide for a mediation if the parties disagree. You could provide for an arbitration, and you know, for those who don't know what mediation is basically the parties hire usually a lawyer or another intermediary just to facilitate settlement negotiations. Now, sometimes that's effective, sometimes it's not. It really depends on the parties involved. If this is someone you're dealing with who you trust or you've known for a while, and you get into a dispute with them, mediation might be effective because it might just require an additional voice in the room. Just basically talk some common sense into people, and well, we don't really want to fight over this. Let's just get someone else to sort this out. Or, you know, you say I owe you $15,000. I say it's 25. Let's just let the mediator sort of weigh in on this, and then we can put this past this. Frequently, you see a lot is also arbitration. Which arbitration is more like a litigation, just faster and it's a little bit cheaper. And there's different associations that run it. One is JAMS, there's the American Arbitration Association, and one of the ways that's beneficial for folks is they frequently have industry experts that are available to decide your dispute. So depending on what you're doing and what the work is, you might want to think about including a dispute resolution provision in your contract to facilitate settlement or facilitate resolving a dispute before it gets to litigation. But you could really spend a whole presentation in and of itself on that topic, but it's just something to consider. Another thing to consider, which is frequently helpful for people that, if under the contract you're receiving payment for your services, in America the rule is if you bring a lawsuit, everyone has to pay their own attorney's fees, generally speaking. However, you can include in a contract, if I have to spend money to bring a collection action or receive payment under this agreement, you have to pay my legal fees. Now the other side might not go for that, but it's something you can include in a contract to sort of protect yourself against like a non-payment situation where someone just stiffs you. It really provides a lot of extra leverage over that party, because they know they can't just wrongly deny you payment, because at the end of the day they may owe you a whole bunch of legal fees. So turning to the next part of my presentation is, okay, so what do you do if something goes wrong? Well, let's say under my holiday design hypothetical, they just decide, you know what, we don't like your design, we're not going to pay you, we contracted for more, and that's it, right? They're just withholding payment. What do you do? I mean, the common practice is to first send a demand letter, right? Explain to the other side why they're in breach, demand payment. I know that in one of the comments there was a question about a demand letter. That this was specifically under copyright, but I think it's a good question. Regardless, can an individual without a lawyer send a demand letter? And the answer is yes. The question is, usually from my experience, demand letters are become more effective and have more teeth, when sent by a lawyer, because then people start to feel that there's a little pressure and legal counsel involved. And let's just put aside, assuming that contract doesn't have any dispute resolution mechanisms, it doesn't provide for arbitration or mediation, you send a demand letter, gets ignored. What do we do now? And I think one of the most common situations that I see, and this is not unique to artists, this is just a common situation that's built into the legal system in the United States. You get these disputes that are like, let's call it like $10,000, where it's like a lot of money, and you don't want to walk away, but you also don't want to go out and pay a lawyer $7,000 to get your $10,000, right? So that's a frequent problem that happens in the world, and fortunately, New Jersey courts and the Hudson County Court, Superior Court has sort of, the legal system is starting to better address those type of situations by providing like expedited cases. And in New Jersey, there's a small claims division, which is part of the Superior Court, and that's for claims under $5,000, which you can basically do without a lawyer. It's sort of, you fill out a form, you put in your case, they schedule it, and you show up on that day, and it's like an elevated Judge Judy type situation where you argue your case, someone decides it, and that's like how it goes. So, and then for claims above $5,000, right, from $5,000 to $20,000, in the New Jersey Superior Court, there's what's called a Special Civil Division, which is similar. However, in that courtroom, there's a lot more procedure involved, and it's very much akin to having a real trial, full-blown trial, and the rules of evidence apply, the rules of civil procedure apply, so there's a lot of formalities involved. So in that court, if you're between $5,000 and $20,000, you're probably going to need a lawyer to do it. However, there's not a ton of resources required for the lawyer to do, because basically it's similar to small claims where you all put in your evidence, and you show up basically for trial on a day. They schedule it once in advance. You show up with your evidence, you show up with your witnesses, you sit in a courtroom with a judge. The judge tries to scare everyone and say, you're here today, you have to put on your case, your expert better be here, your witnesses better be here. If you can't prove your case, I'm going to throw your case out. So I remember I went there with some folks. It was a smaller dispute, and they were like we're gonna, prior to the meeting that morning, like, we're going to try this case and we're going to win. So I'm like, okay, well, I'm ready, we'll go, we'll do it. I gave to everyone their testimony they had to do, Q&A. We sat in the courtroom, they heard the judge, and then they in the hallway, they're like, we got to settle this case. Okay, well, we're not going to be able to prove our case. But anyway, but what they do there is then the judge gives the speech about, sort of tries to force everyone's hand, and then they send you out to a court-ordered mediation with a mediator, and you sit around a table and you try to hash it out. And if you can't, then you have to go back to the judge and do sort of a mini trial with witnesses and questioning, cross-examination, opening statements and closing statements, and it takes about a whole day. But when you compare that to the I'll call the regular New Jersey Civil Superior Court, you're looking at over a year of litigating between complaints, motions to dismiss. You have discovery, which means you're going to have depositions, you're going to have document discovery, you're going to have all kinds of things which take time, they cost money, and New Jersey in particular, it just takes a long time, and then forget it. If you want to appeal it, you can add another year and a half onto that. So the New Jersey courts, state courts are extremely bogged down. They don't have many resources. There's a judge shortage. So it's all the more reason to draft clear contracts and try to resolve disputes before they get there. So that's all I have on those topics. I know I sort of covered a lot. Does anyone have any questions, concerns?
Your kind of structure that you laid out is for New Jersey. Is it kind of the same for New York?
It's very similar for New York. There's for New York, they have the small claims. They have a commercial small claims, which I think, it's sort of has a little bit more dollar amount you can do. And then in New York, the county courts are called New York Supreme Court, which is confusing because of the Supreme Court, the lower court. But but yeah, it's very similar. New York State is very similar. I would say, I may be a little biased. I don't want to insult my home state, but New York courts are a little bit more reliable than New Jersey courts. I don't know. That's my personal view. I guess I'm wrong. But anyway, no, that it is very similar.
contracts a lot, which to me implies two people with lawyers hashing something out. Is there a more informal way to protect
Right,
yourself?
okay. So when I was referring to contracts, I was referring to like a writing, perhaps a negotiation going on. Lawyers don't necessarily need to be involved with the contract. And also, if you're in a situation where, maybe it's someone you know, or it's just not appropriate to like pull out a whole 5-page contract and have them sign it just because of the way you're interacting with that person. At minimum, it's good to just put it in an email and say, here's what I'm gonna do, here's what I'm gonna get paid, doesn't include this, and then see if they say, okay, looks good, and that's better than just having, nothing. It's a even informal is pretty good. It doesn't always have to be a sort of grandiose document. It can just be something very simple, 1 page, an email, and that is a good way to go about things if the situation warrants that.
I wanted to ask about exhibition contracts
Okay.
and liability, and what is like really necessary on both parties to have in there.
In terms of,
I guess it would be liability issues.
yeah, so there can be many liability, I'm thinking,
So for visual arts,
yeah, so are you talking like liability for like property?
loss or damage,
Right.
for the place that's holding the exhibition and for the artists protecting themselves.
Yeah, so I think in that situation, frequently I'm sure the person that is housing your work is going to want to hold you liable for any damage that you cause.
Right, and so that would include like insurance.
Yeah, they
insurance.
will probably put in their insurance requirements, and you'll probably have to add them as an additional insured on your insurance policy. And you might have to indemnify them for certain things, and that means sort of like legalese for if they're held liable because of you, you're going to have to cover their payment. Those types of situations. Those are frequently in contracts with when you're going on someone's premises or putting the works together. That's a common. And there's not. I would say, I don't want to say it's industry standard, but you don't really have a lot of leverage to sort of push back on that because they're going to want, they're going to want protection.
Right.
Depending on what it says. Without seeing the actual provision, it's hard to say, but that is a common.
Are there any
clause.
provisions that you would think should be in there, or?
I would say you don't want to be held liable for their negligence or wrongdoing.
Right.
That would be something that, like, okay, if I do something wrong, or I'm involved in it, okay, my insurance will cover you, but if you do it, if it's something you did and I just happen to be here, I don't want to be liable for that. I don't want to pay for it. So I would try to build that in, and there's language you can use. Provisions like that, yeah. That when you're getting into things like that, you should probably have a lawyer review it because it is very complicated area, and the law is different in different states, and it depends on the exact words, things like that.
So I don't know if you covered this, but like trademarks
Okay.
as well, because I run events, and me and my company, we do events throughout New Jersey, outside New Jersey, and when we think about like just ideas, we come together and say, hey, we never thought about doing something like this, we haven't seen it, we put it together, and then after a couple events, we start seeing people kind of mimic what we're doing. So instead of seeing like moving right along, like just the name of it, everybody's coming to this event, is getting some motion behind it, you see somebody say, okay, running right along, and then we're like, okay, well let's see what their event description is, and it's very similar. You know, so
Right.
when it comes to like even that idea, we think about, you know, intellectual property and stuff like that. But, you know, at times we even have the conversation like, okay, even pursuing this, like, is it worth it? Like, you know, what comes out of this? Is it just like they stop, or, you know, what does that look like?
So, that's a good question. I think Alex,
I can mention that. I was going to talk
yeah,
about
Alex
copyright,
is
but I'm not
he's
gonna talk about
that's his specialty, is intellectual property and trademark. So I don't want to let him take it.
That's what happened.
Yes.
Could you tell us what to expect after you file the default judgment?
For the default judgment?
Yeah.
Um,
Like how long will take process after your court date is scheduled?
yeah, so in a default judgment situation, I'm guessing the other side didn't show up, or they didn't put any answer.
Going to be served.
Yeah, so you probably filed a motion for default judgment. Is this in New Jersey? Oh, New York. Okay. It'll probably take, this is a guess, this is just like 4 to 6 months for them to decide that. Could be quicker, could be longer. It really depends on the judge. It really does. I mean, I've had things get decided in 2 months, I've had things take a year. So, yeah. Okay, that's the best I can tell you. But, yeah, that's. But then you can, once it's entered, then you go about enforcing it and doing that, which, you have plenty of rights to do that. But yeah, it does take some time.
So if that's easier for an artist, then would you like going to a trial? Maybe do I still go to trial?
Well, no. If they didn't show up and you get a default, it's good, but the problem is with a default is they might show up, right? That's the problem. And they can, I forget whether it's a year or they have some time period where they can like say, give the court a reason why they didn't show up and try to have the case reinstated, because they'll say, well, you didn't really decide my case on the merits. You only awarded this default judgment because I didn't show up, and that's not fair, basically. So, in the scheme of things, going to trial and getting an actual ruling on the merits of the case, or getting the judge to rule on the case is a little bit stronger than the default judgment. But if the other side doesn't show up, you just take it and you run with it. That's basically how it goes. Yes.
What would be the process for someone who posts their art online and somebody else like grabs their art and starts selling on their own merchandise, or starts reposting it and claiming it as their own?
Yeah, I think, Alex, do you want to take that one?
What would be the process for stopping them from doing it?
Yeah, or like legal action that you can take.
I think it'd be very similar. Mostly a cease and desist letter is probably your first bet. Write them a letter. You say, "This is my art. You know, you're violating these laws. You're violating the copyright. Stop."
And if they continue to do it?
I mean, that's when you go into the litigation kind of mindset. You know, there's a bunch of factors in whether or not what they're doing is really what you're doing. About how broad your protection is for your copyright and for your art. And it really just depends on what the relationship is in what they're doing to what you're doing.
So like if I like say if I am posting just like my illustrations on Instagram, and then they grab those designs and they start selling it on their merchandise on the website.
That sucks.
Is there, like, what would be the process? You just send them the cease and desist letter, or?
Yeah, that's
Yeah, I mean, the thing is, you send the cease and desist letter, but if they ignore it, which sometimes sometimes people abide by it and say, okay, take it down right away. Sometimes they don't, and unfortunately, that's when you have to, go to the courts and go.
Does it have to be a letter, or like a snail mail letter, or?
No, give me an email, any kind of writing. I think the real, and it's not really about the formality, it's more about alerting them to the fact that you're serious about this and you want to protect your rights, and that litigation will follow. So any way to communicate that effectively is okay.
This seems like a good segue, but before we invite Alex up, thank you, Jon. I do just want to take a moment to thank our wonderful hosts. You are in the Museum of Jersey City History. We're surrounded by Jersey City history. This museum is fairly new, and they've been doing more and more. So did you want to say a couple words?
I'm gonna come up so you can hear me. I'm Mike Ehrman and one of the board members. We have at least two other board members here, Jerome Choice and Martin Pierce. And we have one of our super volunteers. She's here so much that I think I'm gonna start calling her keeper of the house, Margaret Dolan. This is a new, pretty new museum. This exhibit on Hague is the first bigger exhibit that we've had. Been here for a while. Next year you can expect a couple of bigger exhibits to replace this. Actually 3 during the year. One on sports and sports facilities in Jersey City, which will also take a look at breaking the color barrier. We'll have one on women in Jersey City, and also looking at tales of the first 200 years of Jersey City. There's some real interesting things with Native Americans, with blacks, why the British took over but let the Dutch stay here, and we'll be doing that as well. We had a JCAC exhibit here. The remainder of it is the Ward Mount exhibit, which is available for you to see in this little room on the side. Downstairs, if you look to the right when you get down, we have 6 panels, our first sort of overview of Jersey City over the centuries. And then, just so I get this out, on December 1st, we are sponsoring with Councilman Solomon the 100th anniversary of the Colgate clock. At the clock at 3:30 with refreshments. Then on the 10th of December, we will have a rather lengthy 2.5-hour talk on Mayor Whalen. And on January 7th, a talk about the Morris Canal. So you can see we're beginning to get things pretty varied. We'll have talks on 4 major communities in Jersey City this year, blacks, Hispanics, Filipinos, and Indian. We're gonna have a genealogy talk at some point, and more to come. We love having you here. Please keep coming. This house loves visitors, okay? And it's enjoyable to be here in your meeting.
Yes, and thank you to the
You
Office
can
of
look
Cultural
on our
Affairs. Oh.
question was, sorry, we have a website, all of this is on there, please take a look.
Museum of Jersey City History.org, I think I said. There's postcards and stuff downstairs if you guys want to take something home with you. I was saying thank you to the Office of Cultural Affairs for getting us connected, and I love working with other nonprofit organizations in Jersey City, so thank you. Next, I would like to welcome up Alex Bergman, who's going to talk about intellectual property rights and
Quick show of hands. How many of you guys are artists? Cool. Visual artists? Yeah, okay. Sound artists? Music? Yeah, okay. And movies? Cool. All right. So mostly visual artists, and then some other folks. I was kind of focusing this talk on copyright, and I heard a question a little bit earlier about trademark. I'm happy to address a little bit of that. Copyright is one of the very few provisions in the Constitution that gives us very particular rights. It says, this is a right that you have. The thing that copyright protects is the expression of ideas. There's that kind of framing is pretty important for what it is. All of copyright is federal law. You heard John talking a little bit about contracts and all that. That's all state law. Copyright is a uniform body of work, a body of law for the entire U.S. There's a couple of little tiny pockets of state law, but for the most part, it's all federal. Everything dealing with copyright law is federal courts, federal law, and it's statutory with federal common law. So the statute talks about a definition of copyright. The kind of simplified version of it has two requirements. One is that the thing that is being protected is an original work of authorship. It has to be original. The other one is that it has to be fixed in a tangible medium of expression. So, talk a little bit about both of those things, and we'll talk a little bit about what copyright is not, which is it's not trademark, which protects the association of a word or a phrase with a brand. It's to help. Trademark protects consumers to know where what they're buying is coming from. Copyright protects the product of creative endeavors. Patents protect utilitarian aspects of inventions. So copyright doesn't protect any of the utilities. It also does not protect any of the associations of a name. So similar to like run with it or walk with it, that would be something that's in the trademark world, and I'm happy to talk a little bit about what that is. All right, so copyright. You got your two requirements. The first is that it's original. It has to be an original work of authorship. Well, I don't know how many lawyers you know who are particularly good at the arts or well-versed at the arts, but the courts have basically said, we want nothing to do with examining the value of art, figuring out how original something has to be. Even a tiny modicum of creativity is enough to secure copyright. And that has a lot of implications about it, but the important part of it really is that it has to be original. Meaning if you're copying something else, that does not count as original. Again, like a lot of little subtleties, but if your task is to make an exact replica, that doesn't count even if the making of the exact replica takes forever. Even if it takes you a year to make this exact replica, that doesn't count as originality. You can copy life, but you can't copy the copy. It's like what the Supreme Court has talked about. The other important part of that is similarity does not prevent copyright. If two poets are sitting independently in two separate rooms, and they both come up with the same poem, independently of one another, both of those poems can be copyrighted by each of those poets. That has like strange, if you hear two songs that sound incredibly similar, we usually kind of associate the fact that one is coming from the other, but that's not always the case. And if they are not coming from one another, but they're coming kind of just organically from each of the poets, even if it's not particularly original, it still counts as original works. Cool, all right, so the creativity is super minimal. As a work of authorship, it does not protect trademark, we talked about that. It does not protect patents, we talked about that too. The other part of it that people don't kind of always appreciate is that the subject matter has to be fixed in a tangible medium. If you choreograph a glorious 2-hour dance and perform it on a stage, no one has recorded it, everybody has just seen it. Never written down the steps, you've just shown it to a lot of people, there's no copyright protection for that dance, for that choreography. It has to be fixed. When somebody is videotaping you doing this choreography, even if they never show it to anybody, the fact of the video is the thing that fixes the copyright, and that creates the copyright in that dance. Cool? Yeah, I'm happy to take questions.
So the copyright then belongs to the person who recorded it or the actual?
That's a really good question. In that situation, it would belong to the choreographed, to the choreographer, and it also depends on whether it was authorized by the choreographer or not. So it has, there's all sorts of, like, hundreds of implications about each of these little things. But yeah, thank you for the question. I'm happy to take questions during the course. Yeah.
What about voice recordings?
Voice recordings are a complicated part of copyright. One of the main reasons why I asked you guys what kind of art y'all do. Voice recording, like on your phone?
Like if you were up there doing a performance.
And it happens to be recorded.
Yeah, and then
Yeah.
like,
Oh yeah, this is totally copyrighted. And that's another thing we'll talk about in a second, but unlike trademarks and patents, copyright doesn't require the formalities of, for example, contracts. It doesn't require the formalities of trademarks and patents. Copyrights vest, the copyright attaches to the work the moment that it is fixed. Whether or not you've registered it, whether or not anybody knows anything about it.
mhm.
Oh, yeah. Yeah.
So, I'm sorry. So, when it comes to like a performance recording, like let's say you sat there and started singing, right? You started singing certain lyrics, and we all sitting here recording. You got the recording and everything, right? So, if you start to put together like the exact same song, do we then need to go copyright the lyrics and everything if we have this recorded?
Say that again.
So if we were all sitting here and recording you singing, let's say, a song that you created in your house. This is the first time you're performing it. You want us to record. You have a recording. So after that, and then you say, you know what, I want to put this out there officially.
Yeah.
Do we need to go then ask you to transcribe the lyrics, and now we need to transcribe the lyrics and copyright the lyrics?
No, the recording itself creates the copyright.
Gotcha.
Yeah.
So I am trying to write a book. I wanted to know how, if I would need to protect myself, how involved would that process be to try to copyright something like a story?
Yeah. The copyright, the process is super simple for registration, but your writing of the book itself, it's sitting there on your computer.
Yeah.
Itself has already created copyright rights in your book. We can talk a little bit about the things that you don't have because you haven't registered it, and we can talk about that in a couple minutes. But because it's fixed, because you can retrieve it, because you can see it, because the actual phrase is, I want to blank on the name, but like it's not a fleeting fixed thing.
Yeah.
It's fixed. It's there. So the copyright attaches.
Amazing.
But the process of getting it is really simple. You go online, you submit a thing that says here's a sample of here's the book itself. You pay like $100. I haven't looked at the schedule recently, but it's something like $100, and you'll get likely an answer back about saying, okay, cool. It's straightforward, and it's intentionally straightforward. Yeah. All right, cool. Cool. So fixed in any tangible medium of expression. It does not have to be permanent, but it has to be more than like temporary. So like an ice sculpture still counts, even though it will melt. Yeah, a dance doesn't count. Cool, distinction's cool. All right, so when copyright attaches, we talked about this with the book, it attaches at the moment that it is fixed. The moment it is typed, the moment it is painted, the moment it is sung and recorded, yeah, any of those kind of things. The moment you write like a classical piece of sheet music, it's fixed. Cool. All right, so here's some benefits of registration. So this registration process that you were asking about, one is it provides notice to everybody else. Two is it secures your right to collect some damages if you sue somebody, and it allows you to sue somebody for copyright infringement. So even though your book is copyrighted, it is not registered. So if you saw your exact book on the shelves of Barnes & Noble, you could not sue anybody. You could not stop them from doing it until you registered it. And then you registered it, and then you can sue them.
That was
So that's your prerequisite.
Thank you.
Okay, cool. The term of copyright is ridiculous. I'm sorry. It is for the life of right now, for the most part, anything created after in the last 50 years or so is the life of the author plus 70 years for the most part. So it lasts forever. There's been a whole lot of extensions and everything else. There's all sorts of weird stuff for works created before. As artists, you're gonna find yourself on both sides of the copyright kind of balance, right? You want to have protection for your work, but you also want to make use of the ideas of past artists. And that tension, that's a real tension in the copyright law. Right now, things that were created in the 1930s are still under copyright. It's pretty incredible and pretty wild. So there's a lot of focus in copyright law about what copyright actually protects. So, and this is probably the trickiest part of all of copyright, which is it protects the expression, the actual artistic expression that's manifested in the fixed medium. It does not protect the idea. And that distinction is super abstract. So for example, a superhero that flies is certainly an idea, which is not protected. Just because there's nothing stopping you from the fact of Superman's creation in the 60s, 50s? Anybody know?
30s.
30s, really?
Yeah.
That's incredible.
He punches us.
There's nothing in the copyright law that stops you from making a superhero that flies. That's the idea. There is something in copyright law that stops you from creating a comic of a superhero born on another planet that comes to Earth in a shuttle that gets powers from our yellow sun and has a particular type of weakness and is raised by foster parents and puts on glasses to camouflage and doesn't report it. All right, so somewhere between those two is the line between what is protectable and what is not protectable. And so on one side of that, that's helpful, right? Because if the things that you're taking from the past are just the ideas, you're cool. If the things you're taking from the past are the expressions, you're not cool. But on the flip side of it, when you see somebody else doing something that shocks you at how similar it is to something that you've done, you have to frame what it is that you have created in the sense of what is my expression, not in the sense of what is your idea. And that framing of the abstract level of what it is that you created is a real challenging thing, and one of the things that is one of the roles that attorneys play in trying to figure out what it is how to frame what it is that you have crafted in a way that's fair and allows for the future creation of other art. It doesn't stifle innovation in copyright. So yeah, that makes sense? Yes.
Of course, the line becomes really blurry.
Super.
So I'm sure everybody's familiar with Warhol's work. Where do you draw the line from like Marilyn Monroe's photograph that he screened from a newspaper, or the logos of corporations or superheroes actually, or Campbell soup?
Yeah.
So who owns that?
It's tricky. Actually, Warhol lost a case. The Warhol Foundation, I think, lost a case maybe 3-4 years ago. I don't know if it was the Marilyn Monroe photo or one of the other photos. I don't know the details of that, but it's certainly tricky. One of the things that we'll talk about in a second, we're okay on time? We got 10 minutes?
Let's do 10 more minutes.
Yeah, that's perfect. Okay. The analysis goes like this. Somebody took that photograph from life. That person has a copyright in the photograph. Photographs, and this used to be this was a huge issue 60, 70 years ago about whether photographs were copies of the real world and weren't deserving of copyright protection at all. That's been resolved. Copyright attaches to photographs. What did Warhol do? He put it in a completely new context, changed the photography, changed the medium. Was that enough? What did he take? What did he add? And a lot of that analysis comes down to this concept called fair use, which we can kind of skip along to that. Yeah, we can skip along to that. So maybe I can add a little bit of context before we get there. The context before we get there is the way that copyright develops, how copyright law develops, is somebody has a copyright, somebody else does something that they think is too close, they sue them, and you end up with case law about where the lines are for all of these things. one of the major defenses to admitted taking from the past is this concept called fair use. And the basic idea of fair use is super simple. It is everything comes from something. And the more you change your source material, the more important it is for you not to be stifled in your expression. Like that makes sense, right? That's a kind of like a reasonable balancing. So we have statutorily this concept of fair use, where the courts will analyze the series of factors. They're on the bottom of page 2 if you guys want to turn to it. So the courts will analyze. So Marilyn Monroe's estate sues Andy Warhol's estate, and the court will say, well, what was taken and what was added? And the first, you'll see these factors. So the first, and these are non-exclusive factors. This is just kind of the statutory ones, but it's written in the statute, these are non-exclusive. There's lots of other, whatever the courts want to consider, they can consider. But it's an equitable doctrine of where the fairness lies in a particular situation. Super fact specific, very hard to create big picture rules about how a case will come out without looking at the facts. All right, so the first one is the purpose and character of the use. So Warhol, the purpose was for artistic expression and for commentary about our society. Marilyn Monroe is an icon. Treating her as a symbol of America allows you to comment on America. So that goes towards this is fair use. We want to encourage artists to make this kind of expression. Whether the use was commercial, well, everything Warhol did was commercial in some sense, and that was part of his philosophy. And the extent of the transformation, well, he copied her face 2 million times, whatever. He copied her face 60 times, put it on one piece of canvas, changed all the colors around, as opposed to being a photograph of this icon that was meant to show, beauty and perfection. It became something completely artificial and repeated. So these are all, it's a very transformational context in what he was doing. All right, the nature of the copyrighted work. Well, the photograph is a single photograph, but Warhol took all of it. So that kind of goes both ways. Amount and substantiality of the portion used in relation to the copyrighted work as a whole. That's what I just said. And the effect, and this is one of the ones that they talk about a lot, in New York especially, the first one and the fourth one are the two main ones. And the fourth one is the effect of the use upon the potential market for or value of the copyrighted work. Well, that's a complicated way of saying, if you encourage Warhol to do this kind of stuff, will it destroy the market of the original copyright holder? Will people buy Warhol's photographs, Warhol screen prints, instead of the photograph itself? Because if they won't, then why does it particularly matter that we protect that photograph? If the market for that photograph remains, who cares that he's doing this thing? Because it's accessing a completely different market. And copyright fundamentally is a economic stimulus. I didn't talk about this before, but one of the misapprehensions people have about copyright law is not about rewarding artists for creativity. And by case law, the courts have said it several times. Copyright is about encouraging artistic creation. And it encourages artistic creation by rewarding artists, but it's not about rewarding artists. And that makes sense, at least to me, because of that tension that you have as an artist for wanting your work to be protected and not wanting to be stifled by the protections afforded to prior artists. So I don't know if that helps. But that's the framing the courts will use in analyzing the question.
Thank you.
Yeah.
How about, since we have AI now, and all ramifications of people taking images, you don't even know if it's from a totally AI source or if it's partly from an AI source or partly human. Nobody's aware of that.
Yeah.
Where is that going?
As far as I understand, no court has definitively decided the question of whether AI created works are copyrightable. But I'm not 100% sure about that. But traditionally, with just one exception, which we can talk about up here, the creator, the holder of a copyright almost always has to be a natural person. So for the most part, corporations and companies cannot hold the authors, cannot be the authors of a piece of art, with one narrow exception for works for hire. They can be assigned a copyright. They can be assigned the copyrights. They can be licensed to practice the copyrights, to stop other people from practicing the copyrights, but they cannot be considered the authors of the work. And only natural persons have traditionally been. I don't know what the state is of AI. We generally are not affording AI the rights of individuals. And I think it's a huge question in every part of the law. I do not know the answer or where we're gonna end up on it.
Yeah, because you don't know if the source is totally AI or partially AI.
Right, I mean, in those circumstances, right, if you have a piece of art that is a joint creation by AI and an individual, the individual's contribution to that is going to be copyrightable. Whether or not the whole is copyrightable, whether or not there is some strange like joint authorship questions, we don't know. Yeah.
I know that in music, there was a consideration submitted for a Grammy nomination last year for an AI-generated Drake and Weeknd song. And when that happened, the Academy, like immediately was like, we're not accepting any AI-generated works, because like you were saying, it's not, like we can't sit there and pinpoint the people who actually created this work. So that made it non-eligible. So I know in the music industry, they're now creating like different parameters to, well, if you're doing this, it can't be, you can make the work, but it won't be considered for this, and this. So that's kind of like gatekeeping the whole like AI influence in the music industry.
There's so many competing interests in thinking about that. Yeah.
This is historical, hypothetical. If I came across a photo album that was over 100 years old, that has significant photos, and I want to copyright it, would I be able to do that?
You would not be able to do that for several reasons.
Okay.
The primary reason would be it was not an original work of authorship to you.
Okay.
There is copyright protection for works that we do not know the authors for.
Right.
But considering the time frame that it's 100 years ago, I think everything before 1923, I think is in the public domain. I'm not sure what the rules are for anonymous works or for orphan. They're called orphan works if you don't know the author. I don't know what the exact rules are for orphan works in that context.
Now what if this is grandfathers?
Right.
I think it's also still in the public domain because of the age of the photographs. But I can look into it if you'd like. Yeah. I wanted to talk about one quick thing because this is something that I've been asked about a lot, and I think it's particularly relevant to artists, which is who is the author of a copyrighted work, and it relates to this AI discussion. By default, the author is the creator of the work, the holder of the copyright of the original the author of the work is considered the creator of the work. And that's independent of the physical work. If you paint a painting and you sell the painting, you still retain the copyrights of the painting, and you also still retain authorship of the painting. That person can still sell it, but they can't necessarily make photos of it or copies of it or make a book with it as the cover photo, similar things like that. The two kind of complicated exceptions that I think artists come up against to that are works for hire and joint works. So works for hire are works that somebody has paid you to do. Commissions, things that you do for an employer. So there's works for hire are the one exception where the people who actually create the work are not the authors of the work. And the authors for the work is the organization or the company or the people who commissioned the work to be done under certain very narrow circumstances. One is if you're an employer and this project is within the scope of your work, you are no longer the author of your work. The author of your work is the company that you worked for who asked you to do this project. That's a big category of stuff. And just quickly, the employer, if you're an employee, does not mean you have to be an officially employee who's getting Social Security and everything else. There are criteria that's all over case law, with 20, 30 criteria about whether or not you should count as an employee, including, what are the timing of when you have to make the work, where are you making the work, how much control do they have over this work, how much control do they have over your other projects. There's a whole slew of factors that go into the question of whether or not you are an employee. But if you are an employee and this project is within the scope of your work, the author of the work is your employer. Yeah.
What about contractor work?
So that's the second half of the. You got me. You're on it. All right. So independent contracts have additional requirements that's separate from the employer requirements. If you're an independent contractor, it will be considered a work for hire, and you will no longer be the author if there is there's a written agreement that this is a work for hire. For the most part, with some very, very, very particular exceptions, it has to be in writing before the work is created. And it can only be a work for hire if it's a particular kind of copyrighted work. And those are listed in the statute. It can only be a work for hire if it's part of a collective work, part of a motion picture, a translation, a compilation, instructional text, a test, answer materials, or atlases. If you are hired as an independent contractor to create a sound recording, that cannot be a work for hire, probably. Iffy. If you're hired to create a painting, that cannot be a work for hire. You retain the authorship. You can assign the rights of the copyright to whoever you want by contract, but you are the author, and that happens when you fix it. Cool? All right, the other part of that is joint work. Try to go through this quick so we have time. Joint work is work that's collaboratively created by more than one person. And this, artists are super idealistic, and this is, just like John was talking about, these are the kinds of circumstances that if you're comfortable and you can, write out some words to describe the relationship of you and your collaborators to the piece of art. It's really hard to do. I know it from personal experience. I also know it sucks when that goes bad. So a joint work is a work that's prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. It's a huge definition. There's a lot of branches of of questions. But what that means is if these two people are trying to create a singular work of art, they're considered equal partners regardless of their relative contributions to the work. And that's a huge thing. And each of those partners can exploit the copyrighted work non-exclusively. So if Faye and I make a poem, and we intend it to be a joint poem, and she wants to license it to her friend Jerry, who I hate with a passion, she can do it anyway, so long as she splits the proceeds with me. It's an important point to make for collaborating artists and communities. Cool. Yeah. I hope that we have time.
For fan art, so I don't know if I heard or saw this somewhere, but it says that you can't legally sell fan art. Like if it's your own art style and stuff, but you can't legally sell that fan art as your own. I don't know if that's true.
It is not true as a general proposition, but it is likely true in most circumstances.
Okay.
And the reason is because to make fan art, it has to be identifiable with the characters. And the relationship between your fan art and the characters is likely one where you are taking the expression from the past, not just the idea of the characters, but the expression of the characters, and creating a derivative work from it, a work that's based on it. And for the most part, that will probably get you in trouble on something that you're not allowed to do.
Okay.
Yeah. Yes.
So from my understanding about copyrights without registration, if something's copyrighted, but you do not have registration, you're not able to sue, but you can do a cease and desist?
Absolutely. You don't have access to the courts until you file. Their liability for doing the thing that you don't, for copying your work, may also be limited based on their lack of notice of your copyright.
Okay.
And a few other factors.
Gotcha.
Thank you guys so much.
Love it. Thanks everyone for being so engaged and participatory. Just have one more presenter, and then hopefully we'll have some time at the end to do some like formal Q&A, and then also just mingle and chat and ask more personal questions if you want to. This is Carla from the Center for Art Law. She's going to tell us a little bit about the center, the resources they provide. She brought a presentation. So thank you guys for that up. Go to Carla.
Okay, yes. You hear me fine? Yes. Thank you for coming out. Thank you, Amy, for inviting me. It's a pleasure to be here in this lovely museum. So I'm looking forward to share with you a little bit more about the work that we do at the Center for Art Law. My name is Carla. I represent the center. I have legal training, but I'm not a lawyer. And I wanted to share with you a little bit about the work that we do and how we can help artists navigate the legal issues that you likely will face throughout your career. So this presentation is a two-part. Let me get my timer. First, a little bit the work that the center does, and the second part, I'll share a bit how we can help you in more detail. So, who we are a research and education nonprofit. We are at the crossroads of arts and law. Our mission is to provide research and educational resources and to advance the vibrant and arts and law communities. Sorry. We started out as a blog in 2009. We then became a nonprofit in 2017, and today we have a full team with 11 fixed staff and about 20 interns that rotate every year. We are located in Brooklyn, so just a short subway and bus ride from Jersey City. You are more than welcome to visit us. If you're looking to get resources, we have a library. If you're looking to do some research as well. We also have an office in Zurich, Switzerland, and we have collaborators from all over the world. But rest assured that you can contact us easily. Our main footprint is online. So do feel free to access our website and learn a bit more about what we offer. Most of our programs are online as well, so you don't need to be physically located in the US. So who we serve? I understand most of the audience is comprised of artists. We are here to serve you. You are our main clients, so to speak. We also work with attorneys, legal professionals, but our idea is that they are well equipped, that they have the knowledge, and that they can help you better. So we do this all in benefit of the artists. We have more of a focus in visual artists across all the spectrums of disciplines. So painting, photography, sculpture, printmaking, illustration, you name it. We also work with other participants in the art market, so museums, like the one we're at now, educational institutions, appraisers, galleries, dealers, collectors, curators. Our idea really is to be abreast of all the legal changes, the legal issues that may impact all the actors, in the market. But our focus really is on getting you the resources that you need, that you are informed about your rights, and that you can access the resources you need to enforce them. We also collaborate with policy-making institutions. The U.S. Copyright Office, for instance, a while ago was getting some feedback on AI legislation. We've submitted some responses, so we are also looking to work for better laws for you. And what is art law? That's a kind of an expression that we use, but it really means a set of subsets within the law that you artists would likely need throughout your career. So as Alex presented, we work with copyright law. There's also contracts, as per John's presentations, trusts and estates. If you are a foreign artist, we also provide resources for immigration questions, sector regulations, cultural heritage, repatriation, and many more. The center is as I said, it's an international organization, but we mainly work with the US legal perspectives. Although we do strive to offer some international perspectives, comparative perspectives. And coming now to the second part of the presentation, I'm trying to think of some examples and do an engaging presentation of how we can help you. We have here some, I would say, 4 solutions that are more or less tailored to your specific needs, and 2 or 3 which are more indirect ways we can help. So we will start by, we usually receive requests from artists. So if you do have a legal issue, something that you are struggling with, want to get more information, learn more, please contact us. My email will be at the final slide. So you're not supposed to know which kind of solution is the better one to fit you. Just come with us, come to us with the problem, and we will maybe pick up 1 or 2 more from this menu of options on how we can best help you. So in the past year, I think we received over 40 legal inquiries, and we are more than happy to help with each and every one of them. So to start, lawyer referrals. For instance, if you have any legal issue that is quite specific, it's not something we have a material readily available for your specific case, we would usually recommend that you reach out to a lawyer. We have a roster of volunteer attorneys that work at our events, and we're more than happy to recommend you one that would be the best fit for your needs. So here are some of examples of the topics that I mentioned that comprise art law. So we had a curator looking to understand what are her visa options to remain in the US, and she's trying to figure out possible immigration paths to stay in the US for the long term, get a green card. We referred her to an immigration attorney. We also had a copyright infringement case where an artist, I think it's similar to one of the questions that the audience had asked. So one artist believed that her design was stolen, and we wanted to take legal action against the infringer. We referred her to a copyright attorney. Another example, there was an artist faced with the prospect of his artwork being destroyed by the new management of the building in which it was displayed. We referred him to another copyright lawyer. Also, an artist was in the middle of a litigation. He wanted to understand what would be a good settlement amount. We also referred him to a person with specific expertise. And finally, we had a collector. She was seeking to donate an artwork to a nonprofit. She wanted to discuss tax issues, authentication, get a referral for an appraiser, how she would structure that deal. We also send her to an attorney. The second option that I think is a very good resource for you artists are our legal clinics. This is something I'm pretty passionate about. This is my work at the center. I organize those clinics. And what are clinics? Clinics are a specific type of event that the center hosts, where we have a first part with a lawyer, an attorney, or legal professional getting some insight into a specific field of the law. For instance, in our art and copyright law clinic, which happened just the past week, we had an attorney speaking about copyright agreements. So she was talking about licensing contracts, assignment contracts, what is a work for hire. And later, in the second part of those clinics, we have pro bono consultations. So artists can speak to have private, confidential consultations with attorneys to solve their specific legal problem. This is a 20-minute consultation. It's not something that's gonna really solve your problem, but this is it might be a very good first step, just so you have a sense of what your rights are, and perhaps if you want to hire that attorney, you can also continue conversations in another moment. So we have clinics on artist-dealer relationships. We will be hosting our next edition on December 18th, if that's something you are interested in learning more. We have copyright law, as I said, immigration as well, and finally legacy and estate planning, which is, I was curious to learn when I first arrived at the center that this is one of our most popular clinics. I'm not sure if you as artists think of your, how do you plan your, how do you archive your work, do you have a catalog resume, if sometimes there are also participants which are heirs to an artist's estate. People want to plan how their artwork is going to live on after they're not here anymore, how to draft a will. So this is one of our most complex clinics, I would say. And it's quite interesting because besides consulting with attorneys, artists can also consult with appraisers, accountants, financial advisors. So I highly recommend if you're at this stage in your career where you're planning next steps, let's say, to attend our clinics. We also, another resource we can offer, apologies, are case studies. We have some very interesting artists whom we spoke to, who we feel that their careers and that their lessons learned can be a good cautionary tale for future artists. So we do post we have interviews with them, and we post some case studies on what they could bring as lessons for other artists. So for instance, we had a feature series with Jon R. He was mostly talking about his legacy and estate planning work. Vincent Inconilius was talking to us also about legacy and estate planning, but how to legally protect his artwork. He provides consulting services to other artists, so it's quite interesting. And we had Andy Rosen also. He was an actually quite interesting person to speak to. He has a platform called File Protect that allows artists to protect their works through blockchain technology. It also provides like a marketplace for artwork data. So I think these are good resources for you. Not necessarily it's exactly what you're dealing with, but they do provide a good starting point. We also, moving on, we also help you with legal research. The center is not a law firm. We do not have license. Actually, our founder is a licensed attorney, but we don't usually provide you with legal counseling on the center's behalf. But if you have a case where you just need some guidance on what the state of the law is, we would likely send you over a research memo or something that you can rapidly read and get a sense of what the next steps should be. So coming to a few examples again, we had an artist who wanted to, she was illustrator, she wanted to disavow a drawing she lent to a friend years ago. We had some research on moral rights under the Visual Artists' Rights Act and how the person could proceed with disavowalment. We had a curator ask some of the basics of copyright law she would need for her job. We sent some materials over. This next case is quite interesting. We had a journalist who had posted on her website a PDF of an article she wrote. And this PDF contained a copyrighted image of that she did not select nor approve. And she was being accused by the publisher, the person who had held the copyright to the image. She would accuse her of copyright infringement. So we did a quick research on contributory copyright infringement, which means can you be held liable for the copyright infringement of another person just because she was the author. So we sent that over, and finally we had an artist looking to be represented by more than one gallery. She wanted to know how they would interact, what the commission fees would be. So we sent some materials on consignment agreements and what she could do or not do in those provisions. The next resource I think it's quite useful for you. We have articles on many fields of the law. We have, I think, over 1,200 articles on our website currently. Here you can see some of the topics that I mentioned that comprise art law. So we have estate planning, IP protection for jewelry designs, artificial intelligence, some compliance and risk management for the art world, some news on the sector regulations such as the New York City repealing auction industry practices, shifts in the artist-dealer landscapes, a report on a case law decision that's likely to impact damages in copyright law. So it's really a good platform for you to keep informed and get more information. Finally, I wanted to highlight some of our events. We usually host two types of events. We have workshops and webinars. Workshops, they're both are 1 hour events. Workshops are usually aimed at having one person explain, having a very practical approach and teaching you how to do things. We will, for instance, we had a workshop with Minerva on legacy and estate planning from a tax law perspective. So she really spent 1 hour with our artists and showing like what should you be paying attention to, what are the legal consequences of this. And it's not legal advice per se, but it's a good opportunity for you if you're interested in the topic to go and ask some questions, get preliminary answers, maybe get a person to talk to afterwards. I must share that we are having a workshop on December 5th on copyright registration, which was something Alex touched upon. It's really, really important, as he said, for you to, if you want to litigate and pursue your rights in court, you can access more the statutory damages, which they're called, and it's really a good opportunity. We will have an attorney going step by step on the copyright, the U.S. copyright form. So I think it might be very, very useful for you. And on the right, we have just a few examples of some webinars we hosted. Webinars are usually panels, three or more people talking about a specific subject. We had one for licensing artworks for movies and productions. We had another one with people from the New York City Cultural Affairs Department about public art. What's their process like in commissioning works of art, and how artists could also maybe apply, what are the contract clauses, so always with this legal and artist intersection. We also have an annual conference that's more geared to legal professionals. It happens every spring, but we do feature a silent auction in that conference, so it's a good way to get exposure to our other communities if you're interested. So I think I just threw a lot of information at you. I don't expect you to retain everything, but my first piece of advice moving forward would be take a look at our website. We do have a lot of resources there. If you think you're already doing a great job by coming here and understanding that you have to think of the legal aspects of being an artist, so I congratulate you, and please stay in touch. We have a newsletter, which I think it's probably the best next step you can do. Subscribe to our newsletter. You will receive every month a compilation of news, interesting case decisions, or events that are happening the next month, on articles, book recommendations, movies. We really work in all different spheres of art and law. Attend our events. They're also on our website. We have a wealth of resources. You might hit a paywall at some point in our website, so also do consider becoming a member if you think the work that we do is relevant and that it's interesting to you. You will have access to our case law database. You will be able to access all our articles. You have discounted admissions for our events, and you also have access to all of our past recordings. So I think it's a really good value for money. let's say, and artists do have a discounted fee for the membership. So if there are any students in the room, perhaps, or if you know any art students, we also have an internship open until November 30th, so feel free to share with them. And yeah, I think this is it for me. I'm always out of time. And here are my name is Carla, once again. Here are my contacts. The link, you can find the links to our newsletter, website, and events. I think these are the main resources. And feel free to email me if you have a specific question. We will make sure to get back to you with a very thorough answer and provide you with tons of resources, which is what the center is here for. Thank you. And if you have any questions, I'm ready.
Any questions for Carla before we open it up? Let's leave this. Do you mind just kind of leaving that on the screen and then once we start?
Yeah, I said you don't really see it, I think.
It's a little hard to see from the back, but the website is itsartlaw.org. Yeah.
Does it help?
A little bit, yeah. And we'll put this out in the Arts Council newsletter. Yeah. Great.
Thank you.
Thank you very much.
Thank you.
Thank you. So thank you so much, everyone, for being here. And yes, like Carla said, kudos to you for just taking those first steps. And we hope that you feel empowered now with a few more tools to, work for yourself. I can see people getting a little restless. So if you're interested in asking questions, maybe our panelists can come up to the front and we can kind of just do it informally. And if you have to go, you can go. But thank you so much for being here.
I work for the board, so I'm not really